Now, I would like to invite Mr. Kapil Sibal for the address. Over to you, sir.
Chief Justice of India, Honorable Justice D.Y. Chandrachud, Honorable Justice Sanjeev Khanna, Judge of the Supreme Court of India, Dr. Marcin Cieplak, Secretary General, Permanent Court of Arbitration, Ms. Anna Jubin-Brett, Secretary UNCITRAL, Honorable Justice Indu Malhotra, former Judge, Supreme Court of India and currently a member of the Permanent Court of Arbitration, R. Venkatramani, Attorney General for India, Judges of the Supreme Court, Chief Justices of the High Court, Judges of the High Court, Supreme Court, senior advocates, members of the bar, ladies and gentlemen. This is indeed a seminal moment in every sense of the word because we celebrate not only 75 years of the establishment of the Supreme Court of India, but also 125th anniversary of the Permanent Court of Arbitration. The Permanent Court of Arbitration provides administrative support in international arbitrations between states, state entities, international organizations, and private parties. Further, the Secretary General of the PCA may be called upon to act as the appointing authority or to designate another appointing authority for the appointment of arbitrators under the PCA's rules of procedure, the UNCITRAL arbitration rules, or other rules of procedure. It also provides hearing facilities and support in other forms of peaceful resolution of international disputes, as well as administrative support in fact-finding commissions of inquiry. With a population of 1.4 billion people and a growth rate of over 6%, India is one of the fastest growing economies in the world. There are investment opportunities in multifarious sectors of the economy. Given India's vision of becoming a $5 trillion economy by 27-28, foreign direct investment is destined to play a role in seizing economic opportunities where capital earns sizable returns and the domestic economy is given a boost. Efficient dispute resolution through international arbitrations is thus essential in fostering such investments. Commercial arbitrations and investor-state dispute settlement, called ISDS, mechanisms have an instrumental role to play in India's growth story. The rule of law being adhered to in these international arbitrations is necessary to promote investor confidence consistent with India's aim to be an international arbitration hub. The title of today's conference is International Arbitration and the Rule of Law. The rule of law, a constitutional principle, has a pivotal role in particular in international arbitrations. Lord Neuberger in 2015 stated, and I quote, "Arbitration is not simply compatible with the key features of the rule of law, but that it has an increasingly important role to play in upholding those key features both nationally and internationally," close quote. While it is not possible to limit the definition of the rule of law, Lord Bingham gave a famously compact overview of the rule of law in his seminal Sir David Williams lecture at Cambridge University in 2006, and I quote, "The core of the existing principle," he argued, was, and I quote again, "that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered in the courts," close quote. The principle of the rule of law is enunciated in Section 18 of the Arbitration Act, and largely the Supreme Court has been instrumental in upholding this aspect of the rule of law in arbitration. However, there have also been blips on the radar which have sent a negative signal. In some situations, an arbitral award is upheld by all courts in India. However, the process of execution is so dilatory, the very objective of expeditious resolution is lost. Therefore, it's necessary that within the judicial hierarchy at all levels, the significance of expeditious resolution in these matters is understood and acted upon. Further, I have been hearing murmurs of India's supposed withdrawal from the investor-state dispute settlement regime. This characterization, however, is misguided. Rather, a more nuanced view reveals India's endeavor to redefine its position within the global economic order. The BITS, that's the bilateral investment treaty regime, are being renegotiated to ensure a level playing field which will foster growth in India. It's also necessary for India to realize that foreign capital will play a significant role in its investment story. Thus, the investment landscape must be made increasingly fertile, at the same time allow for a level playing field. The fact that the FDI flows in India have been reduced by 30% from 2013 to 2019 as compared to other countries is perhaps attributed to the terminations of the bilateral investment treaties. An investment treaty crafted with a just and balanced perspective will herald a seismic shift, with the Global South asserting itself more forcefully in shaping the very legal framework that shall govern their economic destinies. A just bilateral investment treaty environment will be a win-win for both investors and nations. Just as the investors need us, we too need investors. Thank you very much.